Good morning. So today we are going to be talking about probate court. We're going to give it just a moment here as we wait for a few people to join us as we continue going live. So if you have any estate planning questions related to probate court, please make sure to put those in the chat. And we're going to be talking about probate court. So all week, I really want to focus on this because I think that there are a lot of misconceptions as to what probate is and the process, what needs to go through probate court. And so I have a different probate topic for every day this week. So please, if you are watching this in the replay, please make sure to put any probate questions that you have in the comments. And I will try to get to it on the next live that I do. All of this, we are going towards the end of this week to Friday and doing a probate webinar. And so if you really need to get some information or you have family members that need information on probate court, again, this is a really good webinar for them to be able to join. So if you are joining me live, please feel free to put your probate questions in the comments. And I'm going to try to get to those. I am going to start today with a very basic probate question to just kind of start us off. But before I do that, I just wanted to introduce myself if you do not know me. So my name is Crista Hermance. I'm an estate planning attorney. Our firm is Hermance Law, where we are licensed to practice law in the state of California. So if you are not in the state of California, this is still a great topic for you to get information, but it is always important to work with an attorney in your state to make sure that whatever the laws are in your state are what is going to be applied to your situation. And of course, if you need a consultation, we do have free consultations that we do offer over the phone, and to just see, is it something that we can assist you with? If you are located in California, if the property is in California, if somebody passed away in California, something that ties it to California is something that we could potentially assist with. Okay, so today's topic I want to start with is Probate 101. Okay, so what is the probate court process? I'm going to go over some of the key terms when it comes to probate to really just give you an idea of what probate court is. So when somebody passes away and they own assets in their individual name. And so what I mean by that is maybe there's a home that was owned in their name. So not somebody that they owned jointly as joint tenants. Maybe they had their own bank account. So checking, savings, it's not something that had somebody else on title to that bank account or had a beneficiary designation. The same thing with an investment account. If it's something that was held in their individual name and didn't have beneficiary designations, these are things that are in their estate. Okay, so these are the assets in their estate. So it's any of these assets that would need to go through probate court. And the whole idea of probate court is to be able to have this court process where people get proper notice, creditors are notified, the assets come together to be able to either be distributed or sold and then distributed at the end. And then throughout this court proceeding, there's certain things that need to be done, right? So it's make sure that things are fair with the beneficiaries, the creditors are getting paid as needed. So one of the first things that needs to get started when somebody has passed away and probate court is necessary is you have to file a petition. And this is a petition that basically says, I'm the person who's going to be the personal representative that's going to be in charge of the estate and putting it through probate court process. And you would file this petition asking the court to assign you to be in charge. And this probate court petition, once it gets uploaded to the court, is the easiest way, or filed at the court. It generally takes about, depending on what county you're in, maybe a month and a half to, I've seen upwards of 3 months to actually have that first hearing. And it's at that first hearing where you've put all this stuff in the petition to identify, what assets there are, to identify who the heirs are. If there is a will, you need to provide the original of that will. If there is no will, who are going to be the people that are going to be inheriting. a basic idea of how many assets or how much the assets are worth in that probate estate. And that is what's going to be, that's what's going to go into the probate petition. There's a bunch of other supporting documents that need to be done as well, but this just gets you started. Other things that would need to be done around the same time of that first hearing is if bond is required. There are ways to get bond waive if you have all of the heirs that are in agreement. If the person that's going to be the personal representative is located in the state. But sometimes the judge will not waive bond, in which case a bond is necessary. And I've seen bonds range, anywhere from $800 to $4,000, depending on the size of the estate. And so generally, if there's a will, I would see language usually in there that says bond is waived, but the court may still require it. So it's just something to keep in mind if a bond is going to be necessary. Okay, so once the petition is filed, you have that first hearing. Let's say the judge assigns you to be personal representative of the estate. Now you get these letters. And these letters are basically your authority to now go and start getting access to bank accounts, to statements, dealing with the home, being able to sell the home, right? That's another big one for a lot of our clients that work with real estate professionals that we work with, and they bring clients to us actually. And then this is one of the first things that we need so that they can actually sign the listing agreement to be able to start the process of selling the home. They have to be the one acting in authority from the court to be able to do that. So that's a really big one. We try and get it done as quickly as possible so that if they do need to sell the house, and sometimes it's, look, the mortgage isn't being paid. We're concerned about foreclosure. Let's make sure to get this filed so we can get acting quickly on it to try and get it sold. During this next phase is really the gathering phase. So it's gathering the different assets that are involved. If there was bank accounts, investment accounts, brokerage accounts, maybe collections of things. Now we start having to get appraisals. Appraisals are needed for things where, like especially with the home, there has to be an appraisal that's done. And to figure out what that fair market value is. And depending on the other assets, there may be other appraisals for those assets that are going to need to be done, especially like an investment account where from the date of death, looking at that value to where it's now fluctuated, depending on where it is at in the probate court process. So gathering all of these assets, getting appraisals, selling these assets. Here, you're also going to have the stage where publication should have already been done. So it's where notice is going to need to be done so many times within the process to notify any potential creditors or heirs of the probate proceeding. That's going to need to be done. And this is prior to that first hearing. And then notifying any creditors of the probate also that maybe you've gotten bills for, just sending them notice so that they can file what's called a creditor's claim. So this kind of continuing through that process at this point, probate court is expensive. Anybody who's been through it before is what can we do to avoid it in the future? Generally, when people are at this point, knowing though that they need to go through probate, there's not something that can be avoided, right? It should have been something in the past that could have avoided it. And at this point, it's just we have to go through it. So continuing to gather assets, keep the beneficiaries updated so that they know what's going on. And then once all of the assets kind of get into this place into the probate estate, because at this point you would have already had like a checking account opened in the name of the estate, you're going to now file this, what we would call first and final, and it's a petition with the court. Depending on the circumstances, if you have everybody getting along, they can do some waivers to try and save in cost, not having to necessarily do an accounting. But if a full accounting is needed, then that's going to be some more time and work that's going to need to go into that petition. But it's basically just putting in this petition to the court, just saying, here's all of the assets, here's all of the numbers, here's all the heirs, they've been provided notice, and asking the court to distribute according to this petition, this first and final petition. If it is granted at that point, then you'll get an order and you can start distributing the money according to what that first and final order is of what you've asked the court for. And then, making sure any of the transfers are done, bond payments, if there were additional bond payments that needed to be made. Sometimes if a probate court proceeding will go over a year, you'll have to pay another set of bond fees. But after that first year, if you pay it again, they will generally give a probated amount back to the estate once they're able to get it closed. So it's important to try and, act timely in this, because it does cost money the longer that it's out. Okay, so that is the basic idea of probate. Some of those key terms that I had talked about in there. And again, if you're just joining me and you have any questions, please feel free to put those in the chat, as we're just going through the basics of probate court. So some of the common terms that I see, executor is a term that people use. This is somebody who's going to be in charge of the estate. A beneficiary is somebody who would be receiving as part of the estate. So you would usually see a beneficiary in a will or a trust. But through probate court, it would generally be a will where they have a beneficiary listed, or beneficiaries on assets like checking accounts, savings accounts, investment, retirement accounts. Something else that you may hear is intestate succession. So what intestate succession is when somebody passes away and they do not have a will, right? Their will, a valid will that says, here, I want my assets distributed, who's going to be in charge of my estate. Intestate succession is what the plan is for your estate if you pass away without a will. And so the breakdown of how intestate succession works is, it's basically, what does your family tree look like? And I can't say it's not the same for everybody. It all depends on, are you married? Do you have children? Do you have children? How many children do you have, right? That's going to potentially give different percentages to each child or to a spouse, depending on how many kids there are involved. If you're not married, you don't have a spouse, are your parents still alive? If your parents aren't alive, do you have siblings? Do your siblings have children, right? So it kind of goes down this family tree, and that is what intestate succession is. It's what is your estate plan for you without you having an estate plan in place, right? It's the state's plan for you. And sometimes it works. It's, how people would want their assets distributed, but sometimes it's not. And so it's important to consider, if there's somebody, maybe you have a child that, that left 20 years ago and you haven't talked to. And I see this, after parents pass away and the kids are now going through the estate, and then a long lost child comes in that had nothing to do with the family, but is still entitled to a portion of those assets, because there's nothing that's saying that they didn't want them involved, right? And so they're entitled to a portion of it. And I see that as really having a lot of problems for families when this happens. So something to consider there. Probate court, after kind of just going through that stuff and talking about all of the stuff involved, is a very expensive process. The fees for it are based on statutory fees. And so it's really based on the value of the estate. So to give you an idea, let's say that there is an estate worth $500,000. And this could be a home with a fair market value of $490,000. Well, that $500,000 estate would cost $26,000 in statutory probate fees. And that's not even including the other costs associated with it. So the petition fees, there are bond fees, probate referee fees, publication fees. So it's another $2,000 to $3,000 in fees. It's almost $30,000 for a $500,000 estate. And it's just going to go up from there, right? Based on what the value of the estate is. And what we're seeing a lot now is that people can't actually afford to pay this from the estate when somebody passes away. So they're being forced to sell the home to have to pay the bills and to cover the cost of the estate administration. And so there is a way to be able to, obviously pre-planning on this part would be important. But at the point that a lot of clients come to us is they they're at a point that the pre-planning isn't an option anymore, right? When somebody has already passed away. Okay. I'm going to move to questions as I continue with the probate court information. So if you have any questions, please make sure to put those in the comments. As I do see some here, I'm going to get to those now. Okay. Okay, so can we cancel the executors of a will after probate is passed in court? Let me think. So I think what this means is maybe they've gone through the first kind of phase of being named as administrators, right? Is that personal representative or executor, like you said? And they are now named by the court as executor. So I wouldn't say you can cancel it, but if there is a valid reason, you can file a petition to have them removed as the personal representative. So a valid reason, maybe they're not doing the things that they need to be doing. They're not acting responsibly when it comes to money, right? You found out that they're letting somebody live in the house rent free. Maybe they're taking money and they haven't opened an account in the estate and they are just putting money into their joint account like it's theirs, right? There are things that can be done if they're not holding up the things that they should be doing. You can tell the court this and ask the court that they be removed. Hopefully that helps clear up that question. Okay, another question I see here. There's a mobile home not stated in a trust. Is it supposed to go to probate? So it really just depends on the value of the property, whether it needs to go through probate court or some other probate proceeding, right? It would be based on very specific facts as to what happened, looking at title to see what's going on and what those next steps are. But generally something that is going to need some type of court intervention to be able to clear title. So if it's not probate court, it could potentially be, something to do with, with the just fixing title, right? How does it get fixed? But it still would need to go through probate court. Okay. Those are all the questions that I see for today. Thank you so much for joining me. And again, if you're watching this in the replay, please put your questions in the comments and I will try to get to it when we go live tomorrow for more probate information. So thank you so much for joining me. Have a wonderful day.